Hello students, I am Ishan Bora, Assistant Professor, LG School of Law, and today we'll be discussing about the topic, or I'll say today we'll be continuing the topic of a general exception uh, from the section 80, and section 80 it talks about the accident. Now, by seeing this picture, you must have got an idea about what kind of accident it is and how what is about the accident. Now section 80 of Indian Penal Code talks about accident. It says that accident in doing a lawful act, nothing is an offense which is done by accident or misfortune and without any criminal intention or knowledge, in the doing of a lawful act in a lawful manner by lawful means and with proper care and caution. Now you'll see in the definition in this particular section, you will see that if the person was acting in a lawful manner and he was doing a lawful act and he was not having any knowledge or any intention, criminal intention to do or to make harm to other person, then in that case the person again can take a defense of accident under section 80. Now as you must be having a bare act with you, you'll see the illustration of section 80, that it says that A is at a work with a hatchet, uh, and the head of the hatchet flies off and it kills a man. Now, who it kills a man. Here, if there was no want of proper caution on the part of A, then his act is not an offense. Now, if the A is not having any intention in this particular case, and A and again he have like taken proper care of the things and he acted in a lawful manner, then in that case A will not be made liable for the accident. Now moving further, uh, mm, by seeing this particular picture, you must be getting the you must be getting the idea of the section. Now you see, now you see that section 81, it talks about acts likely to cause harm but done with the criminal intent and but done without, but done without a criminal intent and to prevent other harm. Now the section 81 says that nothing is an offense which is merely by reason of its being done with the knowledge that it is likely to cause harm. It be done without any criminal intention to cause harm and good faith and for the purpose of preventing, avoiding other harm to person or property. Now you must have read the doctrine of necessity and doctrine of alternative danger. In that, in the thought, in that you must have seen that to prevent the major harm, the person sometimes there is a situation in that the person tends to or he has to do the lesser harm. And you must have heard about the example also, if the person is going on a road and he sees that there is a there like his car brakes of his cars are fail, and in that case he has to bang someone. So one side there is a motorbike on which only one person is going, and the another side there is a car in which there are 4 to 5 person are going. So you can see that where the major harm can be. So what will that person do? Like if you are that person, what will you do? In that case, it is sure that you will be banging, or you will be hitting the person who is on the motorbike. So it is like that it is not an offense by reason of it being done with the knowledge that it is likely to cause harm if it done without the criminal intention and in a good faith for the purpose of preventing, and good faith for the purpose of preventing or avoiding other harm of person to a person or property. So in this particular case, you are preventing harm, or causing a less harm, or you can say uh, you're preventing a bigger harm than the earlier one. Now in the explanation, you will see that it is a question of fact that in such a case, whether the harm to be prevented or avoided was such a nature as so imminent as to justify the excuse of the risk of doing the act with the knowledge that it was likely to cause harm. Now again, it is a question of fact. It's like, it's not it is a question fact, as in the person can see that where the particular, like if he goes or if he sees where, if he opt that particular way or he opt that particular option, what will be the uh, uh, quantum of harm, you can say, and the gravity of harm, you can say, is there. So it depends on person to person, and it depends on the knowledge of the person, whether how the person is reacting. Now let's take a one more example. As in, there was a fire in the society, you can see, and in that case, the A, he tried to pacify the fire, to try to control the fire. He pulls down a house, uh, in which there was, like, if the house catches the fire, or the it goes through that particular house, the whole society will get into the fire. So in that case, he pulled down the house. Now you'll see that in this particular case, A has acted in a good faith, and A was having a knowledge, again, that if he don't do this act, then in that case whole society will catch the fire. So therefore A's act is excused, uh, because he was saving, or you can say, because he was protecting the bigger harm than the lesser harm, that, and he'll be he can take benefit under section 81 of this particular act. Now again, by seeing this particular picture, you must be getting that what we are gonna discuss about the next section. The next section is section 82. It says that act of a child under a 7 years of age. Now as you can see, the word dolly in capex, dolly in capex, it is a Latin word which talks about the incapability of a person to commit a crime. Okay. Now moving further, you'll see that section 82 of Indian Penal Code, it talks about the act done by the children, or you can say the act done by the child who is under the 7 years of age. So under section 82, you'll see that it is not an offense which is done by the which is done uh, by the child who is under 7 years of age. Okay. uh, it has been presumed, or it has been taken by the law, that the person who is below the 7 year of age is not having that mental capacity to understand the nature, or you can say to understand the, or he's not having the knowledge of the act what he is doing. Therefore the person mentioned under section 82 and 83, that is the child below the age of 7 years, and the child who are between the 7 to 12 years, they are termed as a dolly in capex. That means that the person is not capable of understanding the things what he is doing. As in, we all know that the children, they don't know what they are doing, and they don't have any knowledge about what a particular act they are doing. Now moving further to section 83, again you will see, as I said earlier, that it talks about the children who is between the age of 7 to 12 years. Now in that case, you will see that nothing is an offense which is done by the child above 7 years of age and under 12 years of age who has not attained sufficient majority of understanding to judge of the nature and the consequence of the conduct of the occasion. Now again, as we all know, the children who are below the 7 years of age, they are not having a little, not a little, what to say, they are not having any knowledge about what they are doing, but there might be possibilities that children from 7 to 12 years of age, they might, it is, again I'm saying might, they might understand sometimes, they can be the mature enough, or you can say sometimes they might understand the nature of the fact, nature of the act, whatever they are doing. Therefore, section 82 and 83, it is, again I'm saying that the person in these particular sections are not mentally capable to understand the acts, whatever they are doing. Okay, so now moving further, you will see section 84. Now, section 84, it talks about the act of a person of unsound mind. As we have seen, act of a children under section 82, who are below the age of 7 years, act of children between 7 to 12 years in section 83, and now act of unsound mind. So what do you think, the person who is of unsound mind, is he liable, or is he not liable for his act, whatever he has done? Now again, you'll see the maxim that furious null voluntas as est. Uh, it means that a person who is suffering from a mental disorder cannot be said to have committed a crime, as he does not know what he is doing. So in this particular state of mind, sometimes the person are not mentally capable to understand the act, though they are of like, they can be the major, they can be the what you say, a old guy or something, but again they don't know the nature of this particular act, that what they are doing. So if in case uh, the person who is unsound mind, or who is mentally ill, he can be he can take the advantage of this section, if he is in real the uh, what you say, is real unsound mind. Now again, moving to the definition, it says that nothing is an offense which is done by the person at the time of doing it by the reason of unsoundness of mind, and is capable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Again, that in this particular section, you'll see that if the person is not knowing the nature of the act, what he is doing, and he don't know that this particular act which he is doing is again contrary to law, or it is against the law, then in that case, if the person is not capable, then he can take the benefit of this section. Now again, coming to the burden of proof, you must have heard, or you'll hear the term burden of proof in the evidence act, that who is having burden of proof to prove that particular thing. So in case of unsoundness of mind, it is upon the prosecution to prove that the person is not insane. Okay, I'm again saying that it is upon the prosecution to prove whether the person is insane or not. Okay, now moving further to the section 85. Now section 85, it talks about the act of a person incapable of judgment by reason of intoxication against his will. Now, you must have seen so many movies, you must have seen so many Saas Bahu serials, in that the person is intoxicated by the another person, and he is not having any knowledge or any will for that particular intoxication, and in this intoxication he commits an act. Okay, now going to the definition of section 85, it is said that nothing is an offense which is done by the person who at the time of doing it, by reason of intoxication, incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law, provided that the thing which intoxicated him or administered to him without his knowledge or against his will. So to take benefit of this particular section, that is section 85, the person has to show that the intoxication which has been administered to him was not in his knowledge, that he was taking something, and again it was against his will. It's like it was not voluntarily. If in case the intoxication is voluntarily, then person cannot take benefit of section 85. You must have got it, the gist of section 85. Okay. Now moving to further section, section 86. Section 86, sorry. Now, seeing this particular picture, you must have got one idea, or you can say small idea of section 85 and 86. Now, section 85, it talks about the voluntarily intoxication, which is not responsible for the crime, and section 86, it says that voluntarily uh, intoxication, which is responsible for the crime. Now, section 86, it talks about the offense of a particular intent or knowledge committed by the person who is intoxicated. Now, again, coming to this particular section, you will see the last section, last line, unless the thing which intoxicated to him was administered to him without his knowledge or against his will. If the person is not knowing the nature of the fact and he has committed some crime or some offense in the state of intoxication, and again if he had some same knowledge as it would have been done if he had not been intoxicated, like if he was of in the normal state, he was aware of this particular fact that he is committing an offense. Okay. And again the person is administered, or you can say the person is has given intoxication, it was without his will and against without his knowledge and against his will, then in that case the person can take benefit under section 86 of Indian Penal Code. Now, I think that you must have got the provisions, I can say, or the gist of sections, these particular sections, and we'll be continuing this general exceptions in our next lecture. For now, I'll be taking your leave, and keep studying, and please go through these sections so that it will be you, and connect it with the live examples which you are having in your life, in your real life, sometimes like the accident or the intoxication, or you can live example as in like you are watching some movies or you're watching some serials or anything, so that you will be connecting the gist, or you can say the idea of the section. So I'll take your leave. Take care of yourself. Thank you.